you first to Sagarushi. And Sagarushi, sir, was a case which dealt with suspension of a member. Not preventing a member from speaking. It dealt with suspension of a member.
Mr. Williams, members have rights. One of them is to attend, one of them is to speak. So, you use your term, if you want to apply the reason you practice with that.
Yes. If you just hear it.
Go ahead.
And I think he said what the decision was, but this is the decision because I have the authority. Further, the powers under Section 52, which is equivalent to Article 165 in our Constitution, must be exercised in accordance with the provisions of the Constitution, and the courts have jurisdiction to inquire into the validity of the exercise of those powers. And to ensure that a member of the House is not barred from his seat except in accordance with the House's rules or standing orders. And that's what we rely on. That's why we are relying here. We are relying. So we are relying. If I'm allowed your protection, Honorable Speaker, if I'm allowed your protection, we are relying on Standing Order 47, Rule 10. And I should quote this Standing Order for the benefit of the Honorable Attorney General. Order 47, Rule 10. Nothing in this Standing Order shall be taken to deprive the Assembly of the power of proceeding against any member according to any resolution of the Assembly. And we are proceeding on Resolution 18, passing this honorable.
Answer the question, Mr. Williams, that 4710 comes under the umbrella of 47.
Because, sir,
There is an order in the Assembly. In other words, whatever the House needs to do to maintain order in the Assembly, it has the power to do. Sir, the preeminent wish is to have order.
if I could respond, I was looking at something that I'm going to quote just now. So when you read Standing Order 47, and then you read Standing Order 10, which is the final rule on the Standing Order 47, it says nothing in this Standing Order. In other words, nothing that was discussed in this Standing Order shall prevent or restrain this National Assembly from proceeding against any member. That's what it's saying. In other words, it is without, it operates without the provisions of Article 47. And it's a constitution copy of the Standing Order. But sir, as I said, there's no great authority. There's no great authority that in this honorable house that the speaker himself. And again, I have to resort. Again, I resort to the security of the utterances and the wisdom of this honorable speaker of this honorable house. Sir, my name is respectfully before this honorable house. So your ruling of the 8th of November 2012, ruling on the right of Mr. Clement J. Rohee to participate in House's Minister of Home Affairs. I refer in particular to paragraph 7. And we said this, sir, in this ruling. As uncomfortable and as unpleasant as it is for me to have to make a ruling in this instance, I must stand on the side of the rule of law. And by applying my own deliberate judgment and adopting the opinion of counsel, and these are the 2 words, find that in the absence of a resolution of this August House that specifically sanctions the minister and directs that he be restrained from speaking in any one or more capacities, I am by law duty bound to rule that he must be allowed to speak. So you're saying, sir, if there's a resolution of this House that restrains the minister, prevents him from speaking, you will be banned and this House will be banned. That's what your ruling is. And sir, if that was not transparent enough for my honorable friends on the other side, this is how you concluded in that ruling. Consequent upon my ruling, members of this House may wish to consider whether a substantive motion on the subject of the honorable minister's participation in this House should be pursued or not. And we have taken your advice, Mr. Speaker, and we have pursued it with the present motion that is being debated before this honorable House. Why should we question wisdom when it's there in abundance? So, I would just like to say, sir, in relation to Article 1, Part 6, which I believe with respect has no application to the issue at hand. Even under the Constitution, there's no right that is an absolute right. No right is absolute. Even under that is limited. It's limited by libel, etc. But in this honorable House also, we have limitations. We can't use certain words in our debate in this honorable House. We can't say what we like in this honorable House. So this is also limited. You know? And the very same order 26 that was referred to by my learned friend and honorable Attorney General also restricts the right to speak in this parliament on a motion. You can't speak on a motion as according to you, which is substantially the same as was discussed before. You can't do that in the same session of the parliament, or in the same parliament. It will go exactly to that. So even in this House, you are restrained. And this honorable House is replete with examples of the application of that principle. Under previous speakers, or your predecessors, Citizen Ryan, the Honorable Citizen Ryan, and the Honorable Gadraj, and the Honorable Rankaran, persons were prevented from speaking in this honorable House, including yourself, Honorable Speaker, including yourself. And if my memory serves me correctly, if my memory serves me correctly,
say that I was bad for speaking in the House. Is imputing
I think my memory serves me correctly, sir. I recall the self-same Clement James Rohee, the honorable member who is now taking a seat again.
Without speaking.
He advised your predecessor, the Honorable Rankaran, not to leave the seat and go outside. So, previous parliament, sir, instances of constraining and restraining the members of this honorable House. And so, in response to the Honorable Attorney General, sir, I'm asking that you find that the sub-judicial rule doesn't affect us and proceed with our business in this